Hello, class. Welcome back to Business Law. This is your professor, Dan Crane. And today's topic is administrative law. Understanding the purpose of administrative law, where does it come from, where does it fit into our scope of laws? Of course, an administrative agency is going to be created by Congress or state or local legislature, and it is specified delegated duties. It cannot have too broad of a delegation, as we'll see. Why have administrative agencies? This is essentially because the legislative branch can't handle and is not built for or has enough expertise in or enough power, employment power, to oversee certain industries such as Environmental Protective Agency, Nuclear Regulatory Commission, the FDIC, etc. Congress can't be monitoring all these things and creating laws for all these things. It's beyond their ability to do so. So the Constitution gives the Congress the power to create administrative agencies. Now, administrative rules and regulations are incredibly important to our topic of business law because it affects many businesses on a daily basis. Just the few agencies I mentioned there, it's clear that businesses need to be on top of these various rules and regulations and be complying with them in regards to attaining their goals. There's a need for administrative agencies because, as I was saying, Congress doesn't have the required expertise, the body of detailed specialized laws regulating a complex area such as Food and Drug, right? Food and Drug Administration. They don't have the time required. And let's see here. Yes. Those are several of the reasons. And I was speaking earlier about the ability for Congress to create agencies. Part of this creation process, we have the delegation doctrine. The delegation doctrine states that Congress can delegate power to agencies, but it's for a specified purpose. This delegation cannot be too broad. In the past, there has been times where there's been too broad of a delegation, and that has been struck down. So it does need to be specific, the enabling act that Congress uses to create the agency, the administrative agency. How are these agencies created? I just used the word enabling act. Here we go, enabling act. When Congress gives powers to an agency, the legislation is known as enabling act. The legislation might not say enabling act, but that's how we define it. We call those types of legislation enabling acts. They can delegate power through the concept of the delegation doctrine. Of course, the power can't be too broad. It needs to be specified. One of the craziest things to me is that an agency, even though it's created by Congress, the agency itself can have all three kinds of power: executive, legislative, and judicial. Therefore, the agency can promulgate its own rules, it can create its own enforcement of those rules, and then it can have its own judicial body to determine disputes of those rules. Administrative agencies, looking through these answers here, are created by Congress to help with rulemaking. Administrative agencies are not described, the specific agency is not described by the U.S. Constitution or listed amongst the three branches of government. They, administrative agencies, of course, have been recognized by U.S. Supreme Court as a legitimate way of creating law. We just talked about the delegation doctrine. That would have been the Supreme Court that gets to be the ultimate decider there in regards to is it a specific delegation of powers or too broad? And were administrative agencies originally created by the president until Congress took over? That would be incorrect. Administrative agencies can be created by all levels of government to assist with delegation of specified purposes. Now, administrative agencies, we've just talked about them. We've gone through a number of them. They're clearly going to be promulgating a lot of different rules and laws that businesses and individuals need to comply with. Is that good? Is that over regulating? Well, let's talk about regulating too much and too little. Laissez-faire capitalism. Laissez-faire capitalism is anything goes capitalism. There are no regulations on the market. That is a bad idea. Things like slavery, selling sex, hardcore drugs, contracts for murder, assassinations, all of those things anyone can clearly agree are bad. It needs to be regulated inside the business market. And then it would go on from there, all the different types of things that need to be regulated. Food and Drug Administration, of course, protecting us there in regards to food and drink at all levels there. As another example. Why regulate the economy at all? Well, clearly we need regulation. Laissez-faire is not going to work. So once we begin to have regulation, that is termed as the free market. The free market does have regulation. It is attempting to reach a goal that's economically desirable, socially desirable. There's public policy objectives here. You're ensuring equal opportunity in employment, protecting employees from unhealthy or unsafe workplaces, preserving the environment, protecting consumers from unsafe products, etc., etc. That would be a regulated market. Administrative agencies regulate the economy for a number of reasons, including, I'll let you read those. You can come to the decision yourself. According to your book, a free market includes freedom from all regulation. As we just talked about free market, even though the word free is in there, a free market includes regulation. So freedom from all regulation would be incorrect. Freedom from regulation of work and environments only. Freedom from regulation of environmental resources only. No, 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 no. Free market includes protecting employees, consumers, and the environment through regulation. Free market attempting to reach socially desirable outcomes. When a state public utilities commission determines both price and quality service for a natural monopoly, providing electricity, this is known as what? A market that does not have any regulation, thereby permitting any contracts, including contracts for sale of slaves, street drugs, or sexual services, is known as what? Direct regulation, a closed market, laissez-faire, destructive commerce. We were just going over some definitions in the laissez-faire capitalism. That is a market that does not have any regulation, thereby permitting all those types of things mentioned. When commerce is legally regulated to obtain desirable social policies and economic results, this is known as a closed market, laissez-faire, free market, destructive commerce. Well, we just talked about it, laissez-faire. That's going to not be regulated. What will be regulated for a socially desirable result, as we said, is going to be the free market. Collection of rules, regulations, and decisions made by the government agencies is known as what? Well, that's what we're talking about here today. It is administrative law. Administrative law would be the laws put into place by an administrative agency. Just, I believe it was last chapter, we were talking about the different hierarchies of laws in the United States. Of course, the supreme law of the land, being constitutional law, is your highest law. Underneath that is going to be statutory law. That's going to be laws created by your state government or your federal government. That would be found in the U.S. Code, or in Ohio, that would be the Ohio Revised Code, is going to be statutory law. Underneath that is then going to be administrative agency law, law promulgated by administrative agencies. And then under that level is going to be what we would call common law, judge-made law, case law. These are legal interpretations or common law created by previous judicial decisions. How are agencies controlled by the three branches of government? There's a variety of methods where administrative agencies have some oversight or some application of pressures from different branches of the government. Legislative control. Congress can always pass a law. They're the ones who had the Enabling Act in the first place to create the administrative agency. Congress can pass a law repealing the regulation that the agency promulgates. Of course, this will be a time-consuming process, can be tough. Both sides, you got to get the votes in order to get that type of thing done. But still, that is a means of control. Also, another approach to controlling agency is to reduce or threaten to reduce their appropriations, their budget. By retaining ultimate control of the purse strings, Congress can exercise considerable informal control over regulatory policy. Again, that's going to require enough voting, so it can be a challenge by Congress once there's an Enabling Act, administrative agency is moving along. It might be a challenge for them to apply those pressures, but if they can get together as a group, then then they're going to be able to apply that pressure stronger. Executive control. The president or the governor, if we're talking about state agencies, can exercise considerable control over agencies that are part of their cabinet departments, that is, executive administrative agencies that are not statutorily defined as independent agencies. Federal agencies, moreover, are subject to fiscal scrutiny of the Office of Management and Budget. Then we're talking about budget right there, Office Management and Budget, subject to the direct control of the president. The president, this would be an executive agency, the Office of Management and Budget. Therefore, going through that office, the president can apply some budgetary, some financial, some fiscal pressure on the administrative agencies. Agencies are not permitted to go directly to Congress for increases in budget. These requests must be submitted through the Office of Management and Budget, giving the president indirect leverage over the continuation of administrative programs and policies. All right, the judicial branch. Well, the judicial branch has judicial review of agency actions, even though agencies will have their own or possibly have their own judicial arm. Appeals can happen as long as things we'll talk about a little bit later on occur. Appeals can happen outside of the administrative agency's judicial procedures into federal court judicial procedures, and eventually that action go to the appeals court, Supreme Court, that type of thing. And those can issue decisions of legal interpretation that are going to might change the scope of rules promulgated by the administrative agency. Classification of agencies, independent agencies. We were talking about executive agencies, independent agencies. Independent agencies are almost always have a commission or board consisting of 5 to 7 members. This is to give the executive branch, the president, less control over the agency, because if there was just one individual there, it's easier for the president to remove the single individual in charge of the agency rather than 5 to 7 whose seats might last for a certain term period of time, and they'll be staggered, making it more difficult for a president to stack in enough people to have control over that agency. A lot of times those agents can't be removed except for good cause. This means that most presidents will not get to appoint all the commissioners of a given independent agency. The hope there is that independent agencies will have a more bipartisan membership of commissions, so the president cannot simply fill vacancies with members of their own political party. In addition to the ICC and the FTC, the major independent agencies are the Federal Communications Commission, the SEC, the Securities and Exchange Commission, National Labor Relations Board, and the Environmental Protection Agency. Agencies are typically classified as what? Well, we were just talking about our different agency classifications. Right up here we have independent agencies. We also have executive agencies. So we're going to be looking down here. The fourth answer seems good, either executive or independent agencies. The rules promulgated created by federal independent agencies may be directly overruled by the president only, may not be overruled, may be directly overruled by the president's staff only, may be directly overruled by Congress only. You're going to be looking for the last one there, may be directly overruled by Congress only. Executive branch agencies. Executive branch agencies serve more under the pleasure of the president, or therefore a little more amenable to political control by the president. One of the consequences of this distinction is that rules that the independent agencies promulgate may not be reviewed by the president of his staff. Only Congress may directly overrule them, whereas the White House or officials in various cabinet departments may oversee the work of the agencies contained within them. The rules promulgated created by federal executive agencies may be overseen by White House and officials in the cabinet department containing the agency. A federal independent agency is generally governed by, we were talking about that, a board of commissioners. It's usually 5 to 7 individuals. Remember, that makes it a more of a bipartisan approach. Typically, it's going to be required to be bipartisan, and because of their staggered terms, it's more difficult for the president to stack it with more politically perhaps biased number of cabinet members. Commissioners of an independent agency are appointed by the president, subject to Senate confirmation. Correct. Powers of agencies. Agencies have a variety of powers. They might have licensing power. They can set rates. They can promulgate business practices, all types of things. The FTC has general jurisdiction over all businesses and interstate commerce to monitor and root out unfair acts and deceptive practices. The SEC oversees the issuance of corporate securities and other investments, monitors practices of stock exchanges. Agencies can have a variety of powers. A variety of powers can be exercised by various administrative agencies. These powers include